Hi, my name is Olivia Lee and I'm an associate in the London office at Hunton Kurth. I'm going to run through some of the potential derogations that will allow for the international transfer of personal data under the General Data Protection Regulation, or GDPR, in the context of the COVID-19 pandemic. The GDPR prohibits international transfers of personal data from within the EEA to third countries outside of the EEA, but also provides specific derogations where such transfers are permitted. This includes where countries have been deemed adequate by the European Commission or where a GDPR-compliant transfer mechanism has been implemented, such as standard contractual clauses or reliance on the privacy shield. Where a transfer can't depend on an adequacy decision or a transfer mechanism, there are derogations provided by the GDPR. And these are for use in very specific and non-routine circumstances. These are set out under Article 49 of the GDPR. In the context of the pandemic, urgent sharing of data with non-adequate countries may be necessary. For example, for the purposes of scientific research, in which case organisations may need to rely on one of these derogations. So they include explicit consent of the data subject, transfers necessary for important reasons of public interest, and transfers necessary in order to protect the vital interests of a data subject or of other persons. These are most likely the three most relevant derogations to consider during the pandemic. For example, the European Data Protection Board, or EDPB, has suggested that those involved in the development of a COVID-19 treatment or vaccine might need to rely on the public interest derogation. A key primary consideration will be considering whether or not it's actually necessary to transfer data outside of the EEA. And bear in mind, of course, that at the end of 2020, when the EU-UK post-Brexit implementation period comes to an end, transfers from the EU to the UK will constitute transfers outside the EEA and will therefore require a transfer mechanism or derogation. And if COVID-related transfers to the UK are expected to continue following this date, organisations should consider implementing an appropriate transfer mechanism in advance of this deadline. If a transfer is necessary, the next step is to identify which Article 49 derogation is the most appropriate for each transfer, and then to consider the limitations on that derogation, including any additional considerations imposed by the laws of individual member states. For example, reliance on the public interest derogation is only appropriate where the public interest is one that's recognised by EU law or by the laws of a relevant member state. With regard to the vital interest derogation, the data subject must be physically or legally incapable of giving consent. Realistically, this is the least likely derogation to apply, but it is referred to as relevant in the instance of an epidemic in recitals to the GDPR. And in order to rely on explicit consent, there cannot be an imbalance of power between those requesting consent and those providing it. That power imbalance might be present, for example, in an employer-employee relationship. And then finally, organisations should consider the regularity of the transfers that it's making. The EDPB provided guidance on data transfers for scientific purposes during the pandemic and emphasised that the derogations under Article 49 are intended for temporary and exceptional use, not for routine transfers. And note that it's also important that data subjects receive notice of relevant transfers so that they can understand how their data is being used and the jurisdictions it's being transferred to. So this should be provided through a privacy notice.